Now it's okay.
Sounds good.
I was asked to speak as a practitioner, as an ex-military lawyer, on my experience with fact-finding NGOs, my interactions with them. I can say it's scenes from a forthcoming motion picture, my affair with NGO, like my affair with Annie, the NGO picture. Hope I got the name right. And this experience comes from 3 different angles or perspective. This of heading international law department in the IDF, looking at strategic levels and on what is the law and so on, seeing the big picture, and that of an ex-criminal prosecutor and a military advocate, and which is really obsessed with the facts and their accuracy. And of course the third perspective of being a civilian, a happy civilian I should say, and having the benefit of some limited amount of perspective and reflection on the past. So I'll start with saying that one basic fact that NGO people often rightfully emphasized in our interaction was that they have no duty to be fact finders or to prove their case to us. It is law enforcement agencies in general and the military law enforcement agencies when it comes to incident involving soldiers which have the duty to investigate suspicions of criminal offenses, including offenses violating IHL or international human rights law. But having no duty does not mean you have no responsibility when you voluntarily choose to search for the truth. I think you have, as an NGO active in the field, a primary obligation not to obstruct official investigation with your actions. For example, going public with an allegation detailing victims' testimony gathered before allowing responsible authorities a chance to confront the potential violators with the details of the allegation may give the suspects time to prepare for the investigation individually and collectively in a way that would prevent the investigation from getting to the truth. I want to mention some practical problems I encountered when engaging NGOs in the field of fact-finding. The first one, a certain NGO used to send us complaints about misconduct of soldiers, naming victims or witnesses willing to testify. With time, we discovered that this organization actually takes detailed affidavits from witnesses, while including only a short summary of it in the complaints. When we asked for the affidavit, the answer was no. The reason given was a concern that small discrepancies between testimonies given during official investigation and the detailed affidavits will be used as an excuse to close the case for lack of reliability of the witness. Now, of course, this may reflect a problem of trust. As an experienced prosecutor, I can say that small immaterial discrepancies are to be expected when human memory, when we're dealing with human memory. In fact, a witness who can repeat a very lengthy statement word by word raises a suspicion of being trained to memorize a fabricated story. Of course, to withhold evidence from an ongoing criminal investigation is a criminal offense by itself. Nevertheless, we try to reach an understanding with that organization without using the power of the law. A second example I will want to mention is facing edited video footage. Nowadays, small and cheap video cameras and cell phones with cameras are everywhere, and they can produce valuable evidence of an incident, such that does not rely on human bias or memory faults. On the other hand, nothing can lie as convincingly as video footage edited to omit uncomfortable information and insert voices and visuals from other places and times to create a fiction rather than a reliable evidence. So this is why the rules of evidence, not just in Israel, I think, are very clear. The footage should be unedited and the photographer should be available to testify about it, or else it cannot be used in court. Unfortunately, we had many problems with NGOs producing problematic footage. In many cases, the problem is that these materials come from local field workers which have a political bias and cannot be considered objective observers. Not to be too pessimistic, there are also examples of cooperation in sensitive circumstances. I remember one case where we were called to investigate a case where a Palestinian miner was shot to death during a rock-throwing incident with soldiers. An NGO claimed it had the details of another miner participating in the incident who could testify to the fact that the soldiers were not in a life-threatening situation, justifying live fire. But we were told the witness was afraid he would be indicted for participating in the stone throwing on the soldiers and would testify only with the promise of immunity. After careful consideration, we were willing to give the witness partial immunity from criminal charges for throwing stones if no bodily harm has occurred and subject to full cooperation in the investigation. Eventually, the youngster gave testimony, but there was not enough evidence to prove misconduct. Another area of often disagreement with NGOs was their attitudes toward our right to respond to allegations contained in reports before publication, a subject that Professor Hampson has mentioned. In this field, practice varied. One Israeli NGO had an appreciated policy, at least appreciated by us, to include in its report the detailed response of the IDF, as given by the IDF, even if it took a few pages at the end of the publication. In other cases, I felt that in requesting to meet with us, the NGOs are just giving lip service to the principle of hearing all sides. In one case, I remember an international NGO asked to meet representative of the military prosecution to discuss investigation regarding allegation of misconduct during the Gaza conflict. Although that organization did not have a good record of impartiality, we decided to meet with them. The meeting was long and many answers were given about the status of the investigations, even ongoing investigation, which is quite problematic. At the end of the meeting, the participants from our side were told the meeting was very helpful and informative and were under the clear impression that the information provided would be reflected in the report. 3 days later, the report was published in New York. The meeting with our people was mentioned just to strengthen the conclusion that the investigations were not satisfactory. The publication created the impression that some questions were unanswered when in fact they were not even presented at the meeting. More importantly, it was clear that considering the quantity of information provided by us at the meeting, the NGO had not taken enough time to assess that information. Obviously, that meeting was designed for the record only, with no intention of seriously considering the possibility that our investigations actually comply with international standards. I think an essential starting point for every fact-finding mission is to clearly define the purpose of the mission. One possible purpose is to inquire whether there is some concern deserving further investigation, to turn on the red light. I think this is a legitimate aim. Moreover, in many cases where resources, time, and access to the field the mission has are limited, this is the only realistic and achievable purpose. A more presumptuous goal is to come to conclusion as to criminal responsibility or the need to bring certain people to justice, whether identified or not. To reach a reliable conclusion of this type, you must conduct a comprehensive investigation, have the means and expertise to do so, and have access and cooperation of all parties involved. And most important, you have to have sufficient time, because criminal investigations take time. In reality, I think NGOs rarely have this ability. In any case, it is important that the language of the report gives a fair reflection of the nature of the findings. Judicial language used in judgment and verdicts is out of place if all you have are partial findings taken just from one side of the conflict. Indeed, this was one of the flaws in the Goldstone report. The head of the mission explained later in an interview to Forward daily newspaper that the findings were tentative, conditional, and, quote, if this was a court of law, there would have been nothing proven. But the language of the report itself says an unequivocal judgment of war crimes committed. However, what is the reason why NGOs fail by making unsubstantiated determination where caution is in place? I think a key to understanding this phenomenon is the influence of the media on NGOs. NGOs want to attract media's attention. It is easier to do this with dramatic stories that end with an exclamation mark, not with a question mark. There is a risk to NGOs trying to be fair and even-handed. Let me illustrate this with this true story. One of the Israeli NGOs published an annual report. This report acknowledged the fact that there was an improvement in the condition of human rights in the territories compared to the previous year. Less Palestinian civilians killed in military operations, less administrative detainees held, and less military checkpoints and roadblocks. Of course, the report was still critical of Israeli actions in many fields, but at least in Israeli media, can you guess what the headline was? Of course, an improvement in the condition of human rights in the territories, says NGO. Because man bites dog is news. I was told that one of the workers of this NGO said they would never repeat such a mistake. I hope it is not really the lesson learned, because the price of short-term gains and media attention can be long-term loss of credibility when eventually the truth is revealed. Next time this organization will cry for attention, it may be treated like a boy who cries wolf. Fact-finding, of course, is not done just by NGOs, and even not just by international and external bodies. It is also done inside the military. Criminal investigation by the military police and board of inquiries have detailed rules and protocols as to the collection and evaluation of material. But there is a third form of fact-finding in the military: command investigation or operational debriefing. This is a form of fact-finding that is supposed to be quick, done by commanders in the chain of command or by other military experts, close in time and place to the incident. It is mainly a tool to improve military performance and draw lessons for the future from an operation, but can be used and is used, among other materials, to create a primary factual picture as a basic for a decision if a criminal investigation is needed. Although the law does give some important tools to this fact-finding mechanism, mainly a privilege against disclosure in court designed to encourage soldiers to cooperate without the fear of self-incrimination, it does not prescribe detailed investigative procedures. Inside the military, I often heard arguments against regulating command investigation. It will damage the flexibility needed, slow down the process, and similar arguments identical to those heard from NGOs as to their lack of detailed procedure. I think they are equally not convincing. Now, some improvements were made in the military during the years, but there is still a lot to be done. Of course, some NGOs which find fault with command investigations fail to notice the same methodological flaws in their own fact-finding mission. What one should acknowledge, and I'm close to the end, one should acknowledge that even a fair and professional fact-finding process does not guarantee the truth. I saw from close-up how even an official criminal investigation, with all its powers and tools, sometimes fail in the judicial test. Some of the witnesses turn out to be unreliable, defense experts find flaws in the physical evidence, and new evidence comes to light and changes the picture. Furthermore, I will risk being considered a heretic to say that even a professional court, with all the benefits of subpoena powers and all its experience and its chance to directly assess witnesses under cross-examination, still can be wrong sometimes, acquit the guilty and condemn the innocent. NGOs should not be held to higher standards, even when eventually their findings are refuted, as long as they apply a fair and professional fact-finding mechanism and describe their findings without inflammatory language. NGO can have a positive role, even from the viewpoint of law enforcement authorities. They can often bridge over the lack of trust potential witnesses may have in law enforcement authorities of the other side. Bring their complaints before the authorities, convince them to testify, and help them in the process. The real question NGOs should ask themselves is, are they really interested in the truth, whatever it is, or are they just looking for facts to support their prejudgment? If there is a will, there is a way, and probably several reasonable ways they can choose from. I think this book can be of assistance. Thank you very much.